Reading debate. Sir Jeremy Wright.
Thank you very much indeed, Mr Deputy Speaker. And can I begin with an apology to you and to others in the chamber for the fact that I will not be in the chamber for some part of this debate due to some other parliamentary business I have to attend. But I want to start my remarks by recalling that the fundamental purpose of this bill is to locate the decision on whether Rwanda is a safe country to send people to with Parliament, rather than with decision makers in individual cases or with courts reviewing those cases. And I say that, Mr Deputy Speaker, because a number of the amendments before us today seek to undermine that fundamental purpose by transferring decisions on that question away from Parliament again and back to the caseworkers and courts. And so they are, I'm afraid, wrecking amendments. They are incredibly elegant wrecking amendments, and they come from an honourable and fundamental opposition to the purpose of the bill, and an opposition which, Mr Deputy Speaker, I entirely understand. I will confess to the House that I did not find voting for this legislation a comfortable choice. It comes very close to the line on rule of law acceptability, but in my view stays just the right side of it. And crucially, it asserts parliamentary sovereignty on an issue of huge political significance, where that issue is central to the delivery of a key government policy. And that significant and central issue is whether the government of the day is entitled to pursue a policy on illegal immigration that contains an element of effective deterrence. And I think the government must be able to do that. And for a deterrent to be effective, it must be clear. The deterrent to those who are really economic migrants seeking to reach the UK under cover of our asylum system is that they may end up in a different country instead, in this case, Rwanda. In order for that deterrent to be meaningful, the prospect of transfer to Rwanda must be a real one, which it is not easy to evade, which means the headline judgment on Rwanda's safety must be clear to all, subject, of course, as it should be, only to persuasive individual circumstances. And Mr Deputy Speaker, I think that approach is worthy of support for two reasons. First, that illegal migration is a huge problem that the government must be able to pursue innovative solutions to, especially in the absence of credible alternatives. I give way to one of the
Fulton giving way, and he's making an excellent point about how we have to have innovative ways. Isn't it this the reason why other countries are looking at what the UK is doing? The likes of Austria, Germany and Italy have all talked about using third nations, because there needs to be a solution to this problem that he's so elegantly putting out.
I think one friend is right. I'm conscious, Mr Deputy Speaker, not to trespass into second reading territory, but he's right about that. And of course, as our right honourable friend the Minister has pointed out, other international agencies also make use of Rwanda for these purposes. But the second reason that I think this approach is the appropriate one is that the judgments about the safety of Rwanda in the terms of the bill are ones which at this point Parliament is as able to make as any other body. And at this point I should say I'm grateful for the information with which we have been provided, including the country information notice that was referred to earlier in the debate, which in my view supports the conclusion that Rwanda is safe for the purposes of the bill. But Parliament's decision-making, Mr Deputy Speaker, on the safety of Rwanda must have integrity not just for now, but for the future too. And I am, I have to say, troubled by what I might describe as the absolutist, if not the eternalist nature of the wording of the bill. The bill says that Rwanda is safe and must be taken as such for a variety of purposes, and Parliament's judgment on that will stand, as far as I can see, until new legislation is passed. And that is why the Noble Lord Hope's amendments 2 and 3, are interesting. Now, I should say I cannot support them as they are, because they essentially transfer authority to the Treaties Monitoring Committee to determine whether Rwanda remains a safe country, based on the compliance or otherwise with the treaty. Now, I don't think that can be right, because the bill is intended specifically to give Parliament that authority, and Parliament should, in theory at least, retain the option to consider breaches of the treaty and nevertheless conclude that Rwanda remains a safe country for the purposes of the bill.
Well, my right honourable then if I give way.
I give way.
I'm very grateful to my right honourable learned friend. He makes a very powerful point, which I have much sympathy with myself. Isn't there something to be said for the government thinking between now and future stages in a way which might be capable of reconciling the legitimate concerns of Lord Hope's amendment, which is, I think, fair and honest, because facts change. And if Parliament sets itself up as an arbiter and decider on fact, it must have a means of changing its decision if the facts change, just as anything else would. Keynes comes to mind, I'd say to the Minister. Can we find a way forward on that?
My honourable learned friend anticipates my conclusion. I agree with him entirely. In fact, he in advance agrees with me entirely. But I'm conscious my honourable friend also wished to intervene.
Giving way. I was just keen to hear further on how he would see Parliament's role in assessing any future breaches of the treaty in light of what he has said.
Yes, I'm grateful, my friend. And essentially, it seems to me that Amendments 2 and 3, though, as I say, they are flawed, they do raise the valid issue of what happens if Rwanda at any point falls below the standards expected of it to justify safe country status. Now, the bill establishes in legislation the largely unchallengeable conclusion that Rwanda is a safe country for the purposes of the bill, because Parliament says so, without any mechanism for Parliament to say differently if the facts change, save, of course, presumably for fresh primary legislation. I give way to the Honourable Member.
I thank the Honourable Gentleman for giving way. What concerns me about what he's saying is, and I see almost two contradictions coming there. On a one level, the Honourable Member is saying about the sovereignty of Parliament, and then the issue about whether Rwanda is safe or not can be changed. But then we have a situation where our Supreme Court, the highest court in the land, said, after reading all the evidence, that Rwanda was not safe. And for Parliament, and yes, it is sovereign, but it's become almost a dictatorship, because it's a bit like saying, person A was found guilty in a criminal court, but because we here in Parliament don't like that, that person therefore must return back to court and be sentenced. And it's like, using parliamentary sovereignty in the most nonsensical way.
I'm afraid I don't accept what the Honourable Lady says. First of all, and I think the Minister made this clear, the government hasn't ignored the conclusions of the Supreme Court, which we must remind ourselves were in 2022. They have responded to those concerns, and new information is now available for Parliament to consider, and my point is that this is, on the government's invitation, for Parliament to decide and to determine whether we consider that it is, on the evidence available to us, a safe country. We may all reach different conclusions about that, but the premise of this legislation is taking into account the concerns the Supreme Court have expressed. It is nonetheless for Parliament to determine whether Rwanda is a safe country or not for the purposes of this legislation. I simply say that for Parliament not to be able to say differently if the facts were to change, save for primary legislation, is simply not sensible. I think we all hope, perhaps expect, that Rwanda will remain a safe place for migrants to go. But if we could guarantee that indefinitely, we would not need the treaty the government worked so hard to secure, or the monitoring committee designed to scrutinise compliance with it. So it seems to me that although the government is entitled to reject the amendments before us today, it should give some thought to the situation that the bill is now in, breaking new ground to give Parliament specific authority over a judgment which will bind many, but which Parliament cannot easily revise, even if it comes to believe that revision is necessary. The treaty and the monitoring of its terms do provide a mechanism for Parliament to be alerted to significant changes in compliance, and I would ask my right honourable friend the Minister, and indeed his colleagues in the other place, to consider how Parliament may be given further scope to engage with this judgment if the need arises. Now, I do, Mr Deputy Speaker, appreciate the government itself retains means by which it can revise its judgment of the safety of Rwanda. But the government has, in this legislation, clearly and deliberately transferred the judgment on safety to Parliament. And if it's a judgment in Parliament's name, it must be right for Parliament to retain the capacity to reconsider it and, if necessary, to revise it.
Yeah.